Offer 3 is we can keep the current charges. I'll never remove any videos. There'll be a new video about every day that I'm in custody on multiple YouTube channels. There'll be a full public trial. There'll be appeals to the Supreme Court. There'll be millions of dollars in civil damages against Pima County, U of A, and Tucson Police, and I'll special action appeal the slap. That's my offers, because I know I'm right. I did not commit any crimes.
Okay, so what you just heard was one of the plea deals that Lane Myers was supposedly going to offer to the prosecution in his harassment and stalking case. As you were about to hear, that did not come to fruition for Mr. Myers. As I have said all along, he has taken a plea agreement. Now, I was going to wait until the sentencing to go over this, but I have had so many people ask about it. We are going to go ahead and read through the plea agreement, and then we will talk about the sentencing on July 1st. First and foremost, though, thank you to all of my channel members and subscribers. If you are new here, please consider hitting that subscribe button if you enjoy the content. I would most certainly appreciate it. For now, let's go ahead and get started. The State of Arizona versus Lane Jeffrey Myers. The State of Arizona and the defendant agree to the following non-trial disposition of the above entitled action under the terms and conditions specified within this agreement. The charge. Having been placed under oath by the court, defendant Lane Jeffrey Myers agrees to plead guilty to the charges of amended count 14, stalking, distress, fear, a class 5 felony, on or about September 12, 2024 through February 22, 2025. Lane Jeffrey Myers intentionally or knowingly engaged in a course of conduct directed at Shannon Walker, which would cause Shannon Walker to reasonably fear for her safety or the safety of family in violation of ARS 13-2923A1. The second count, amended count 1, aggravated harassment, court order in place, a class 6 felony. On or about March 16, 2025, Lane Jeffrey Myers committed aggravated harassment of Shannon Walker by committing harassment pursuant to ARS 13-2921 when a court issued an order of protection, an injunction against harassment, or any other criminal-related injunction against and in favor of Shannon Walker. Injunction against harassment, and that the order or injunction had been served and was still valid in violation of ARS 13-2921. In addition to the factual basis and mens rea provided by the defendant, the grand jury or preliminary hearing transcript is hereby expressly incorporated within the factual basis required by this agreement. So he pled guilty to 2 felonies and agreed to the dismissal of all of the others. It goes on to give a range for sentencing. If sentenced to prison, the defendant must serve approximately 85% of the sentence imposed before he is eligible for release on any basis. Upon completion of the prison sentence, the defendant will be placed on community supervision. The duration of community supervision is 1 day of community supervision for every 7 days of the prison sentence imposed, not actually served. Violation of the terms of community supervision could result in the defendant being required to complete the prison term imposed by the court. Probation. The available term of probation with a Class 5 felony is 3 years. The available term of probation for a Class 6 felony is 3 years. Whether the defendant's sentence is suspended or he is placed on probation is within the sole discretion of the court. Unless otherwise stated within the special terms of this agreement, there is no agreement that the defendant will be placed on probation. The defendant understands that he may be incarcerated for up to 12 months in the Pima County Jail as a condition of probation, as well as being assessed a monthly probation fee. Fines and assessment. The court may require the defendant to pay a fine of $150,000 plus a 78% surcharge. If the defendant is unable to pay any fine or assessment in full on the day of sentencing, a one-time $20 payment charge will be assessed in addition to any fine imposed. He better get on that GoFundMe. he's going to want to pay that $150,000 in full on the day to avoid that extra $20 payment charge. I mean, that's just that's salt in the open wound. He's going to want to have that $150,000 ready. So let the e-begging begin. Special terms. As to CR 20251060-001, the parties agree that at the time of sentencing pursuant to ARS 13-719, the defendant shall be served with an injunction that prohibits the defendant from contacting the victim. The injunction does not expire and is valid for the defendant's natural lifetime unless a dismissal is granted pursuant to ARS 13-719E. Standard terms and conditions. Dismissal of other charges and allegation. This agreement amends the charges filed in this case to the offenses set forth above. That this agreement, unless rejected or withdrawn, serves to amend the complaint, indictment, or information to charge the offense to which the defendant pleads without the filing of any additional pleading. All other charges and allegations in this case are dismissed. Next is a section on restitution. The defendant agrees to pay restitution to all of the victims named in the original indictment, even if they are not named within the specific charge to which the defendant is pleading guilty. The defendant further waives any and all rights to have the amount of the restitution he owes determined by an evidentiary hearing. The victim's restitution claim form shall be accepted as conclusive proof of the victim's economic loss. The defendant understands that he is jointly liable for the entire restitution amount. The defendant specifically agrees to make restitution to the victim for losses suffered as a result of the course of conduct of which the defendant may only be a part. Pursuant to ARS 31-254, if the defendant receives compensation for work while incarcerated, a portion of that compensation shall be ordered to pay restitution. Victim rights. All victims listed in the original indictment retain all of their victim rights pursuant to Rule 39, Arizona Rules of Criminal Procedures, even if their names do not appear within the specific charge to which the defendant is accepting responsibility. The defendant agrees to have no contact with any of the victims listed in the original indictment without the prior knowledge and consent of either this court or the probation department. Waiver of rights. By accepting this agreement, the defendant understands that he is giving up the following rights: the rights to a jury trial, the right to confront and cross-examine the witnesses against him, the right to present evidence and call witnesses, knowing that the state will compel witnesses to appear and testify, the right to be represented at trial by counsel free of charge if he cannot afford to hire his own counsel, and the right to remain silent, to refuse to be a witness against himself, and to be presumed innocent until proven guilty beyond a reasonable doubt. All right, we're going to speed through some of this because not all of it is applicable. Concurrent and consecutive sentencing, they just don't have an agreement whether or not the sentence is going to run consecutively or concurrently. We'll find out on July 1st. Forfeiture, nothing in the agreement is going to be construed to protect the defendant from civil forfeiture proceedings. If a firearm was used in the commission of the offense, the defendant automatically forfeits any and all ownership interest in that firearm. This case obviously did not involve a firearm. He is going to pay all of his extradition and detainer costs to Pima County, Arizona. Rejection of or withdrawal from the plea agreement. Defendant's disclosure of prior convictions. Obviously, we already know that he has disclosed his prior felonies to the prosecutor already. Defendant's future unlawful conduct. Defendant's future unlawful conduct. The state may withdraw from this agreement if the defendant is charged with or commits a crime between the time of the court's acceptance of this agreement and sentencing. So from the day the court accepts this agreement and July 1st, he should probably stay off of YouTube. Stipulations or recommendations by the parties. The state's participation in this plea agreement is conditional upon the court's acceptance of its terms, conditions, or provisions. Waiver of double jeopardy claims. Essentially, if this plea agreement falls apart, everything reverts back to the way it was before the plea agreement was put into place, and he can't claim it's double jeopardy. They are just going to go back to the state that the case was in prior to the plea agreement. Appeals. Defendant hereby waives any right to raise and or appeal any and all motions, defenses, probable cause determinations, restitution orders, and objections which the defendant has asserted or could assert to the prosecution and to the court's entry of judgment against defendant and imposition of sentence upon defendants consistent with this agreement. He cannot appeal this. Once this is done, he cannot appeal. So for everyone out there saying that he is playing a long game and he has a plan and he's going to appeal this, he cannot appeal this. What's done will be done. Motions and dismissals. The defendant understands that he gives up any motions, defenses, or other matters which have been or could be asserted in this case, regardless of their merit. If the defendant is permitted to withdraw from this agreement for any reason, the original indictment and allegations shall be automatically reinstated. The state will be permitted to file any additional charges not previously filed as a result of this agreement. Entire agreement. This agreement contains the complete agreement between the parties concerning this subject matter and supersedes all prior written or oral communications and understandings between the defendant, defense counsel, and or the state. Anything else is null and void. Then we get to the defendant's acknowledgements. He is acknowledging that he has read all of the provisions of the plea agreement with the assistance of counsel and he understands them. He is acknowledging that he is waiving the right to a trial by jury. He is waiving the right to appeal, that he is acting on his own volition with a clear mind, and he is agreeing that in this written plea agreement, it contains all of the terms and conditions applicable and that any promises made by anyone, including my attorney, specifically any predictions as to the sentence I may receive that are not contained within this written agreement are without force and an effect and are null and void. No assurances, promises of leniency, or representations have been made to me or to my counsel by the state of Arizona or by any of its representatives which are not contained in this written agreement. And it was signed and dated on June 9th. Now the only thing we can do is wait until July 1st for sentencing. Thank you so much for watching, guys. Please like, comment, subscribe. Let me know what you would like to see, and I will catch you at the sentencing.